now with us, but as we are still continuing the separation, or the horizontal separation, now I will ask Professor BELOV to take the floor.
Should it be on? I would like first to thank to Senior Francisco that she has invited me to the conference. And I will try to fulfill the two requirements of the organizers. First, to be brief and to finish in 20 minutes, and second, to be slowly. To speak slowly for the translation purposes. Having said that, I have to tell you the structure of my presentation. So today I'm going to speak about two main issues, two main groups of issues. The first one concerns the conceptual issue of the possible limitation of specific financial power, specific branch of the state power, and the financial power. And the second part of my presentation will concern the relation of the principle of the balanced budget with the financial power. How does the principle of the balanced budget influence the separation of powers in general, the financial power in particular, and whether it really induces some structural changes in the horizontal separation of powers. I have to admit that I come from a purely constitutionalist background, meaning that I'm a constitutional lawyer and not a specialist in public finance. So that's why I would like to excuse me if I'm not very precise in the argumentation of the financial issues, and please focus your critiques on my constitutional point of view. Having said that, I would have to clarify first what do I understand under financial power, and why do I think that the creation of such a specific branch of state power and the financial power would contribute to the better understanding of the process that we're actually observing. I think that the limitation of that financial power may allow us to expose the typical systemic relations between the institutions that are concerned with public finance management. It can demonstrate the typical logic which is inherent to the management of public finance and which cannot be easily attributed to the legislative or to the executive process. Furthermore, we are observing the emergence of new institutions reshaping the institutional design of our constitutional systems. Just to mention one of them, which is maybe also to the main colleague the budgetary and financial councils the new star emerging in the horizon. But also some traditional institutions as the courts, audits, and the central banks are getting new competences in regard to the balanced budget principle. And last but not least, the conceptualizing of the new financial power may contribute to better understanding of the vertical relationships in the national constitutional systems, but also in the emerging multi-level constitutions of the European Union. So I think we can delimit that financial power on the basis of three criteria. The first one is the sphere of social reality and the typical relations towards which the public governance is directed, and these are the relations concerning public finance. Second, these are the functions performed by state institutions. And third, these are the specific set of institutions that are acknowledged in that set of functions. So the functions, the institutions, and the typical sphere of social reality are the triple criteria that, according to my opinion, would allow us to limit that new type of power. A very problematic issue would be how can we differentiate the constitutional dimension from the non-constitutional dimension of the financial power. So where can we draw the line between the finance administrative law from the one side and the constitutional law from the other side? Due to time constraints, I'm going to answer that question in the discussion if you ask me something about this, or I'll keep that recommendation. So, I think that the principle of the balanced budget is both evidence for the emergence and development of that new domain of public governance, and a kind of result, intermediary crown of the process of institutionalizing of the public finance management. And I'm wondering whether we can speak just of balanced budget, or we can broaden the scope and actually deal with specific principle of financial stability, public finance stability, in which we can include also other measures which are directed towards sustainable development or sustainable public finance, which are not directly related to the budget itself. So now I would like to address the issues which directly concern the principle of the balanced budget, and I will speak about four types of influence, about the four groups of influence that the principle of the balanced budget has on the horizontal separation of powers. Then I will discuss whether the principle of balanced budget influences the typical relations between the governments and parliament. Second, whether and to what extent does it influence the role, function, and status of the courts, and the constitution of the courts in particular. On third place, I will discuss the role of the principle of the balanced budget towards new institutions like the budgetary and financial councils, and if I have time, I will also discuss the influence of the role of the people that the people play in the framework of the constitution. So, does the principle of balanced budget influence the typical relations and the structure of the relations between the key institutions of the executive, the legislative power, and the government and parliament? So, the question is whether the principle of balanced budget is a paper tiger, or it's a new financial framework, or it's a dog which is buried somewhere, and the question is where is the dog buried? I think that the principle of balanced budget does not introduce severe structural changes into the type of relationships, apart from two groups of issues. First of all, some institutions provide compulsory hearings or reports by the fiscal and budgetary councils, or by the, for example, other similar institutions which are more expert and legal. And then, of course, there are some constitutional limits to the amount of borrowing, to the procedure of borrowing, accumulated public debt, which may, to some extent, influence the government-parliament relationships. However, I think the principle of balanced budget may lead to a new functionality of these relationships. Because the principle of the balanced budget emerges, in my opinion, as an argumentation center, cornerstone of the new political discourse. So this discourse may be a very abstract one. The euro as a value itself, the budgetary stability as a new ethos of policy making, or it may be focused on specific discourses. For example, the electoral discourse, the government and oppositional discourse. That's why the principle of balanced budget may serve as an argumentative liaison between the different policy discourses, which I have, for example, mentioned. When it comes to the influence on the constitutional courts and the other courts, I think the principle of the balanced budget may fulfill three functions. The first one is that it may serve as an occasion for reflexive and reactive development of social patriotism. The second function is that it may serve as a stimulus and precursor of judicial activism. And the third function is that it may serve as a tool for prophylactic naming of Prometheus. What do I mean under these speculative notions? I'm very glad that we have a colleague from the Portuguese Constitutional Court that may correct me or confirm if I'm right, but I think that the jurisprudence of the Portuguese Constitutional Court, which was not directly related to the principle of the balanced budget, but which was focused on the evaluation whether the anti-crisis measures taken by the Portuguese government and parliament are constitutional with regard to the principles as welfare state, social equality, and social rights. So that jurisprudence balancing the principle of welfare state with the principle of sustainable public governance may serve as an example of something which I call the social patriotism, namely judicial defense of the welfare state towards its disproportionate limitation by virtue of the new principle of the balanced budget. An opposite example might be linked, I'm not quite sure because I didn't make sufficient research there, but which might be linked to and reflexive to that social patriotism jurisprudence of the Portuguese court. Because the Hungarian constitution prohibits the usage of welfare state defense by the constitutional court in case of public debt, which is above 50% of the GDP. So if the Hungarian state has more than 50% debt of the GDP, then only defenses based on personal rights and rule of law, but no defenses based on welfare state and social rights can be used by constitutional courts. So the court is obliged to remain blind for the potential destruction of the welfare state in cases of constitutionally presumed financial emergency. And the Constitution presumes, in a rather conservative way, that not 60 but 50% public debt is a sufficient amount to block the welfare state defense. And last but not least, I believe it's relatively obvious that the emergence of a new star of the horizon of the principles and the emergence of the principle of the balanced budget, if we assume that it may gain or has gained a constitutional principle status, may serve as a stimulus and precursor for judicial activism. Because the constitutional courts will be able and will be actually called upon to define the meaning of the principle, to adapt the principle to the system of the constitutional principles, to balance it with other principles, or precisely welfare state, sovereignty, people's sovereignty, and also to use it as a criteria for constitutionality of the current legislation. To a lesser extent, this might also be the case with other courts, and more precisely with supreme administrative courts, which might be tempted to use, or even required to use that principle as a criteria for measuring the legality and the constitutionality of the governmental acts. Some words about the budgetary and fiscal councils. I'm doubting whether we can give a clear answer to the question, what are these new institutions? Are there attempts at limiting the populism and for increasing the expertise and the knowledge in the sphere of public finance governance? Or they are the limitation of new domains of democratic accountability? So here we have, I believe, the case of constitutional elitism versus constitutional populism. So we have to reflect on that issue. Another issue is whether we can put these budgetary and financial councils into the realm of the constitutional law institutions, because in most of the countries they don't have a formal constitutional status, apart from Germany, where we have the Stability Council, which has some maybe common functions to the newly established, more recently established budgetary and fiscal councils. Last but not least, I think the principle of the balanced budget has influenced also the allowed constitutional participation of the people in the financial policy making. So the question here is more practically than analytically, because I do not have sufficient time to develop the detailed argumentation. The question here is, what do we have here? Do we have a putting of the straitjacket in the due time in the name of future generations, which might be one approach, or it's a step towards a new financially based constitutional elitism? Because it is obviously a very tempting issue to deliberate whether the constitutional provisions adopted by the recent generations can really project trajectory of the future generations, and whether really the future doesn't start now, issue which was also discussed in the previous panel. So I think we're getting involved here in something which I call future generation games. And these games may be like Hunger games, very robust and tough, or more moderate ones. If we have constitutional provisions provisions that are not amendable or which are hardly amendable, then we might have really tough future generation gains because we'll have a really putting of the straitjacket into the on the shoulders of the current sovereign. If we have more surmountable cases, for example, if we have legislative provision of principle of balanced budget, then we have a real version of these future generation gains. So in conclusion, I would like to stipulate several things. First of all, I think the provision of the principle of balanced budget enhances the functional delimitation of the financial institution and financial power. So, of course, the principle of the balanced budget is a matter of political choice, and it is a substantial constraint on some forms of public finance management. Thus, it gives the budgetary and financial policy of the state a conservative outlook, hindering the constitutional neutrality, which actually does not exist. Reflect, for example, the way the welfare state principle was adopted was also not very neutral. I believe that the principle of the balanced budget does not massively reshape the institutional design of the financial power, but however it enhances the role of the more expertise-based and less political and thus less democratic actors, for example, the constitutional court, the courts, the specialized administrations, and limits the discretion of the classical traditional stakeholders in public finance management, the parliament and the government. The principle of the balanced budget may serve as an argumentation strategy in the political communication, and consequently it may influence the way of policy making and thus also the horizontal separation of powers. Thank you very much for